welcome. I'd like to welcome you all to really what is a wonderful event in the life, the history, and the spirit of the University of Pennsylvania Law School, the Roberts Lecture. It's through this annual address that we celebrate the life and career of Owen J. Roberts, really one of the most formidable public servants of his generation. He was an illustrious alumnus of the law school, class of 1898, and served as a distinguished member of the Supreme Court from 1930 to 1945. And during his tenure there, he wrote and participated in a number of very significant opinions. He, of course, made political and legal history by his support of the majority in West Coast Hotel versus Parish, upholding the federal government's authority to regulate commerce. That opinion, which was the subject of a Roberts lecture earlier on, obviously continues to be deeply relevant to the current political and legal debates about the role of the federal government. Let me also mention, by appointment of the President, Justice Roberts headed blue ribbon investigations of the Teapot Dome scandal, which was the Watergate scandal of his generation, as well as the attack on Pearl Harbor. I also should mention that one of the most interesting decisions he ever made was to step down from the Supreme Court of the United States and ultimately to become Dean of the University of Pennsylvania Law School. That is a career move for which I, the current Dean of the University of Pennsylvania Law School, have a great deal of personal affection. To honor him, the law school established the Roberts Lecture in 1957 with the support of the Order of the Coif, and then later the law firm in Montgomery McCracken, the firm which was founded by Justice Roberts. I'd like to thank the organizers and founders of this lecture, but also to make specific note of a number of people who were really instrumental in the creation of it. Now Judges Tom O'Neill, Norma Shapiro, Dolores Sloviter, as well as Harold Kramer were all very important in this lecture, and of course it has become a Penn institution over the years, and we are really thankful to them. Ever since its establishment, the Roberts Lecture has showcased some of the finest legal minds in the country. I could go through the list among the luminaries: Felix Frankfurter, Erwin Griswold, Guido Calabrese, Antonin Scalia, Lou Pollack, and of course the inimitable Henry J. Friendly, who delivered his Roberts Lecture in 1975. I cite Henry J. Friendly because he is the subject of the lecture today. He has been called, and I quote, the preeminent appellate judge of his era and one of the greatest federal judges in the history of the federal bench. Today, we have the distinct pleasure of having with us as the Roberts Lecture someone well-versed in the work and lore of Judge Friendly, as well as someone who is himself regarded as one of the great judges of his generation. Before formally introducing our distinguished lecturer, however, I'd like to recognize a number of people in this room who are very close to Judge Friendly. Judge Friendly's daughter, Joan Friendly Goodman, who is a professor of education here at the University of Pennsylvania. Her husband and Judge Friendly's son-in-law, Frank Goodman, who has been a member of our law faculty since 1973. Judge Friendly's grandchildren are here, including Ellen Goodman, who was a law professor at Rutgers University, as well as Dan Simon, who graduated from Penn Law School in 1983. Clearly a very deep connection with Judge Friendly, and we welcome you all to the lecture here today. So now let me turn to today's speaker, the Honorable Michael Boudin of the United States Court of Appeals for the First Circuit. Judge Boudin will speak today about Judge Friendly's craft in deciding cases, which will, in a larger sense, shine a light on how judges in general come to their decisions. In light of recent and impending Supreme Court nominations, there is perhaps no topic that focuses the legal and public mind more intently than the question of how a judge should decide a case. Reflexive labels such as originalism, textualism, liberalism, and conservatism do not capture the nuance of a craft demanded when a judge must face an ambiguous law and precedent in a deeply complex and divided legal environment. Our speaker today has so aptly described the qualities of judicial judgment that go into such choices. It requires, he has said, and I quote, an almost instinctive sense of proportion, as in sensing how to fit the punishment to the crime, an ability to think about multiple factors at the same time and to consider remote consequences, always asking the question, what will happen next? An ability to gauge and advance the reaction of others to events and arguments, to separate and prefer the reasoned response to one based simply on emotion, and a willingness to make decisions and to do so based on incomplete data. Let me say that is the essence of practical wisdom and the reasoned judicial role. Judge Boudin speaks with authority on the subject, having himself been called, and I quote, one of the most influential and brilliant judges in the country with an eloquence and breadth of interest almost unheard of among lawyers. He is also particularly suited to comment on the judicial craft through the eyes of Judge Friendly, given his long exposure to the mind of Judge Friendly, in whom he found a mentor and a friend. Judge Boudin began his career as a clerk for Judge Friendly, having graduated in 1964 from Harvard Law School, where he is president of the Law Review. According to legend, Judge Friendly kept a list of all of his clerks in a desk drawer. He ranked the clerks, and as the story goes, the name at the top of that list was Judge Michael Boudin. Judge Boudin has remained in the top ranks of the legal profession throughout a fascinating career that includes private practice, government service, and many years on the bench. Following his clerkship with Judge Friendly and later with Justice Harlan, he joined the Washington firm of Covington and Burling. There he spent 20 happy years as an accomplished antitrust lawyer working on antitrust cases such as the Penn Central reorganization. He also gained a reputation which would follow him to the bench as a person intensely devoted to craft and committed to exploring all sides of an issue. He left the comforts of Covington in the late 1980s to help lead the Justice Department's antitrust division. But then in May of 1990, the first President Bush nominated Judge Boudin to the U.S. District Court for the District of Columbia. But he resigned within 2 years because of the difficulties of commuting from Cambridge, where he lived, to D.C. One of the greatest tributes to his professional reputation occurred 2 months later, when President Bush nominated Mr. Boudin to the First Circuit, that is 2 months after he'd resigned. As one of my colleagues described it, that was like a quadruple play in baseball. It just never happens. He has since been on that court for 18 years, serving as chief judge from 2001 to 2008. During that period, he's established himself, like his mentor, as one of the most thoughtful and respected federal judges in the United States. Colleagues, fellow judges, and lawyers describing his, and I quote, intellectually honest, prepared, penetrating, supremely fair, reasonable, and non-ideological. Better known, some say, for his organized readings of Shakespeare than for his political views. Fortunately for the judiciary, Judge Boudin, like Judge Friendly, has produced a line of clerks who have continued this intellectual legacy, including our own colleague, Ted Ruger, who, like so many before him, went on to the Supreme Court clerkship. Judge Boudin is also a thoughtful and even playful judicial scholar. He was a lecturer on antitrust law at Penn Law in the 1980s, as well as more recently at Harvard Law School when he moved to Boston. He has contributed a number of influential articles to law reviews, including one particularly delightful piece, Antitrust Doctrine and the Sway of Metaphor, that explores the impact of literary metaphor on decision-making through what he aptly describes as a literary invisible hand. Would make Judge Posner proud. Not surprisingly, the piece has been quoted over 50 times. Finally, in addition to being a serious jurist, Judge Boudin is also known as a warm and engaging man. As one story goes, while at Covington, Judge Boudin initiated an icebreaker in which he periodically would invite new shy associates to his home to perform plays, classics being his favorite. So, what more can be said about an able judge and expert in antitrust law? He has one other connection to Penn Law School. He married Martha Field, a former member of the Penn Law faculty, who now teaches at Harvard Law School, a move for which we will forgive her, but just for today. It is therefore my great pleasure to introduce one of the country's most esteemed judges, a disciple of Judge Henry Friendly, and a relative of Penn Law, by marriage once removed, the Honorable Judge Michael Boudin.
The Dean is unusually generous, unduly, in his introduction, but that, of course, is a tradition at this law school. After my last antitrust class here in 1984, a University of Pennsylvania cup was presented to me by the students filled with chocolate crunch. And not long after, working at an ALI project of some kind with Jeff Hazard, a chance expression by me admiring his tie led him to take it off and present it to me. And you will admit that it's a rather attractive tie. But as the subject of tonight's lecture, Judge Henry Friendly would have said at this point, enough of pleasantries, it's time to work. How judges decide cases is a subject on which Judge Friendly sometimes touched in his writing. An example was a book review published in this school's law journal of Carl Llewellyn's great work on appellate judging. But Friendly seemed mildly amused by Llewellyn's rather complicated schemes and his unique vocabulary. Judge Friendly's own bent was for history rather than jurisprudence. And after decades of advising clients and litigating cases, Friendly's craftsmanship was really in his bones. But of course, interest in the subject of how judges go about deciding cases continues to flourish. Recent scholars have offered differing views on whether and to what extent federal judges are or should be influenced by precedent, by statutory language, by the slant of the president who appointed them, by their own political affiliation or the affiliation of their colleagues, by the size of their circuits, by the presence or absence of dissents, by the practical consequences of their decisions, and by their own social goals and temperaments. Judge Friendly's own decisions are, along with the work of a handful of other judges, truly the gold standard in American appellate judging. So it's worth pondering what his body of decisions can teach us about him and about the enterprise of deciding appeals. Appellate judges have the peculiar burden of seeking to do three different things at the same time. First, to determine and respect the law, this vast collection of constitutional precedents, statutory phrases, canons, prior decisions, and similar paraphernalia. Second, to reform doctrine if it is permissible and appropriate in light of new insights, of experience, of social imperatives. And finally, to get the specific quarrel before them decided in a just and practical way. Naturally, a potential exists for conflict among these goals, but let us defer that problem for a moment. Along with other strengths, Judge Friendly brought to this set of tasks, law finding, law improvement, and sound outcomes, two qualities in which perhaps no American judge has excelled him: a skill in wielding the legal tools and a quality of judgment that had been honed by years of law practice and of service as general counsel of a great corporation. His educational and professional background, relatively familiar, and have been considered elsewhere. So taking as a surrogate examples from a few of the cases decided in a single Second Circuit term, let's explore how he went about deciding cases and how this was informed by his own experiences. Common law judging, of course, is built on precedent. Blackstone thought it was the foundation principle and the crucial restraint, the words are quite eloquent, that kept the scale of justice even and steady and not liable to waver with every new judge's opinion. But of course, many lawyers and scholars now doubt whether prior cases count very much and how far judges feel themselves constrained. And the causes of the doubts are multiple and familiar. The sharp doctrinal shifts by the Supreme Court throughout the 20th century, realist legal philosophy and its various offshoots, the preoccupation of courts with policy and with consequences. For a law student in the 1960s, the most vivid metaphor for this attitude was Anthony Amsterdam's likening of the conflicting canons of construction as pool balls on parallel racks, waiting for the judge to choose the one desired to support the result. Friendly, by contrast, took precedent extremely seriously, albeit less as a command than as a presumption and a source of information. His decisions regularly sifted through numerous earlier cases, distinguishing some on their facts or in light of the circumstances in which they had been considered, discerning trends, explaining aberrant outcomes. His brain seems to have been built for this function. But we then remember that he was schooled in the 1920s at Harvard by the masters of the art of weighing and distinguishing cases at a time when precedent got more consideration in the classroom and at least formally more respect on the bench. Consider this sequence from a friendly concurrence in a decision. The authorities on which the panel majority relies are not so strong as they might appear. It is indeed profitless to argue whether dictum or holding best characterizes Judge Frank's statement in York that a spurious class action tolls the statute of limitations for late interveners. What is clear is that the interveners in question were not before the court, and that the the statement was initially affirmed without the benefit of argument from counsel. While the question was raised on rehearing, the court's attention at that time centered on the quite different problems that led Judge A.N. Hand to withdraw his concurrence and the Supreme Court later to reverse. And what has just been quoted is only a portion of what Judge Friendly, in a concurrence, had to say about the handling of the authorities in the majority panel opinion. As a result, he seems to have concurred. Now, part of this attention reflected for Friendly the importance of maintaining stable rules. He'd been a practicing lawyer and an advisor to businessmen, so he understood the need for predictability and protecting reliance. But his immersion in the case law gave him something more subtle than the discovery of some legal doctrine to be discerned, applied, and perpetuated. It was really an education in the rules and the reasons that judges had given in their addressing of the same problem, a sense of the facts that pushed the decisions one way or the other, the direction and limits of the dominant tendency. Whether this education led him to affirm or to modify or to undo the precedent was for him a different question. And of course, he was not a slave to precedent. Being himself something of a temperate reformer, Friendly was ready enough to alter and improve law where he thought this was allowable. He titled his tribute to Roger Traynor, ablest judge of his generation. And here the second verb is telling, said that Traynor illuminated and modernized every field of law that he touched. Now, a judge of an intermediate federal court lacks the same latitude to alter common law, the same latitude as a state Supreme Court justice. But Friendly himself helped advance the concept of federal common law in a much narrower realm, and he felt free to improve doctrine all over the federal case books when he thought it was appropriate. In Friendly's day in law school, statutes took second place to case law. But of course, in the New Deal, there was a great torrent of legislation washing out of Washington, and the interpretation of these statutes has been a central part of federal judging ever since. The task is quite as demanding as common law development, and not wholly different in its criteria. In fact, some statutes are very much a charter for judges to develop their own common law. The antitrust laws, of course, are practically a blank. And even the more complex statutes, done in great detail, constrain in some respects, but endlessly create quandaries, omissions, confusions, often on subjects to which the legislators gave no intention at all. Friendly agreed in construing statutes, of course, that words mattered. But his view was that language was rarely as rigid as it might first appear, and that both in the case of statutes and common law precedent, the purpose and history were as much a key to understanding and interpreting. Friendly had been trained at Harvard College as a historian, and he was always half in love with that calling. He enjoyed identifying the real-world problem that had led to the statute and trying to understand the compromises that had been made in enacting it. And he could not only see the parts of the statute in relation to one another with great skill, but rather like an archaeologist could excavate down to prior versions of the statute and relate them to the present version in aid of interpreting it. In one case, he gave a limited reading to a change in statutory language, deeming a broader one at odds with the basic structure. And he borrowed Justice Frankfurter's elegant phrase that Congress did not inadvertently add a colonial wing to a Gothic cathedral. In another, he concluded that while this history would give no sufficient reason for cutting down the words that Congress used, it does afford ground for refusing to expand them. A dramatic instance of foray into statutory construction was a civil rights case in which the protesters were charged in state court with disrupting traffic in New York during the World's Fair. Based on a Reconstruction era statute, the defendants, aided ably by, again, Professor Amsterdam, claimed the right to remove to federal court all criminal prosecutions of any kind against civil rights demonstrators. The defendants didn't contest the fairness of the New York courts, which would have been an established ground under the statute for removal to federal court, but relied on a different provision of the statute allowing removal of any proceeding brought, quote, for any act under color of authority derived from any law providing for equal rights. This is language so bland and broad as to give some linguistic warrant for the position they were taking. After all, might not the First and 14th Amendments be regarded as just such laws? A trail of statutory history and language, however, led Friendly to conclude that under color of authority, even assuming that the phrase could apply to private actors rather than those deputized to assist officers, required some law that not merely permitted, but encouraged or directed the act being prosecuted. One who blocked a subway entrance in aid of a civil rights demonstration, Friendly said, was not acting under color of authority in committing the trespass or obstruction. He did not dwell unduly on the fact that mass removal of these prosecutions to federal courts designed for a smaller number of larger cases would have paralyzed prosecution, but it wasn't his mind. Friendly's power of memory and concentration gave him an unusual command of another facet of appellate work, namely the record and the blossoming range of interconnected issues that the appeal would be likely to spawn. In a classroom, attention at any one time is usually concentrated on a particular doctrine, doctrine of consideration, or the tying a law under Section 3 of the Clayton Act. Appeals are fundamentally different most of the time because a circuit court is usually confronted in any case worthy of argument, and about half of them are thrown out without argument or decided without argument, with a welter of problems, some substantive, some procedural, some unknown to or ignored by the lawyers. Each of these problems, in turn, is likely to, or often will, trail a succession of related issues that have to be resolved just to solve the single problem, which is itself one of a number in the case. For example, in dealing with a single claim of evidentiary error, of which there may be a great many in a complicated criminal trial, a judge may have to consider not only the merits of the claim, but whether an objection was raised, whether a proffer was made by the offering party, what grounds were given for and against the ruling, what standard of review should be applied, whether if there was error, it's plain or harmless, according to whether the objection was preserved. And that's a single issue. So figuring out what happened in the case in the court below, what the parties said, what the document said, and then developing this profusion of issues and their interconnection is a large part, often the hardest part, in coping with an appeal. Once those issues are arrayed, often an experienced judge can get rid of the issues very quickly, but the confusion in getting to them is a major part of the problem. Any decision by Friendly exhibits his ability to handle this problem, but of course his greatest challenge and his most triumphant success was a series of extraordinary opinions designed to establish a value for the entire Eastern Railroad network when it was nationalized. And this was an endeavor he himself has described at some length in a modest, unduly modest tribute to his friend and colleague John Minor Wisdom, who served on the court. Now, another problem that federal judges on appellate courts face is factual disputes, although at one remove from the witnesses. Consider what an appeals court judge is faced with when the question is whether the affidavits established a material issue of fact barring summary judgment, or when they are reviewing for clear error the factual findings by the trial judge in a bench trial, or when they are asking themselves whether on motion to acquit that was rejected, a reasonable jury had enough evidence before it to convict beyond a reasonable doubt. These are essentially factual problems. Friendly was not primarily a trial lawyer, although he had some trial experience. He was an experienced administrative lawyer, and of course, that involved both administrative litigation and mustering and analyzing facts on appeal. A good example of how he used his experience is Friendly working out the opposing inferences in a dispute as to whether a company committed an unfair labor practice by firing a worker, at least in part because of his union activity. The Labor Board examiner, we now call an ALJ, had rejected the charge against the company, noting that the worker had been fired only after his criminal record of violence became known to the company. But there were a few fragments in the record that might support an unfair labor practice charge, and the board reversed the examiner and held the company liable for committing an unfair labor practice. Friendly agreed that the question was the reasonableness of the board's interpretation, not Friendly's own view of the merits or that of the examiner. He further conceded that the union only needed to show that anti-union bias had played some role in the discharge. And further, he agreed that the board was not obligated to defer to the examiner, even though the examiner was the one who had heard the witnesses, including the management people who had made the decision. Because, as Friendly neatly explained, demeanor might be a part of the evaluation of the witnesses, but the ultimate inference drawing, sort of logical processes and association of probabilities with the contentions, was something that the Labor Board could do quite as well as the examiner, and they had the ultimate authority. But after applying his own scalpel to the evidence, which he considered in meticulous detail, he found that, quote, of the 4 facts and circumstances relied upon by the board to show an anti-union motive in the discharge, all but the second reason, management's knowledge of the employee's union activity, are somewhat unsatisfactory. He explained why at some length. And the second alone is not enough. This was all based on his own study of the record and synthesis of the arguments. There's no recollection in the mind of the law clerk who served him that the law clerk was consulted at all. Friendly's legal knowledge and analytical skill wouldn't have surprised anyone familiar with his breathtaking academic record at Harvard Law School or its own repeated attempts to lure him back to its faculty. His later books and articles, almost all written as a working judge, would form an adequate bibliography for an entire career of teaching. A number of books and countless articles, usually of great complexity and subtlety. But it was the marriage of these very powerful intellectual gifts with the practical experience that account for the character and quality of his decisions. It may have been the bent toward the practical as well as more material rewards that led him to join the Root Clark firm after his clerkship rather than taking up Harvard's teaching offers. But it was surely the decades of lawyering that exposed him in a powerful way to how the world worked. This was not an experience limited to courtrooms. One lawyer who knew Friendly quite well described him primarily as a business lawyer. And what can be gleaned of his work in Pan American World Airways during its heyday, where he served also as its vice president and a board member, indicates that business lawyering as well as litigation was part of his repertoire. Now, evidence of what he took from these kinds of experiences lies in numerous passages in his decisions, because a perception of how the world worked was usually a premise for some step of reasoning in the decision. In the same labor board case, simply a convenient example mentioned earlier, the company had sought to support its good faith in firing the employee with the criminal record by saying that its lawyer had so advised firing. Here is Friendly's delicious treatment of the point. Having apparently learned a lesson from the prior proceeding against the company's management engaged an experienced labor attorney who endeavored to keep their conduct within what he considered the range permitted by law. We would not be misunderstood as saying that advice of counsel, even if precisely followed, is a defense to an unfair labor practice charge. See Welsh Scientific versus NLRB. But when a party that has erred places itself in the hands of capable counsel who gives reasonable advice for the future, and there is a significant improvement in its conduct, it ought not be viewed as having such a propensity for sin that every episode is given the worst interpretation, or to be condemned by indiscriminate repetitions of the phrase that its conduct, quote, from other cases, must be assessed against the background of its earlier unfair labor practices. Friendly knew, too, that an appeal might well have a life of its own after it left the appeals court. And he was adept at taking this into account. One small example, it's an instance of his being about a half step ahead of the Supreme Court in protecting defendants' rights and being reversed for his troubles. It shows how carefully he thought about the stage beyond the one before him. The occasion was a famous capital case in which Friendly's panel had heard a review on appeal of the denial of a petition for writ of habeas corpus. And the defendant, now sentenced to death, had murdered a doctor in his home and almost fatally injured the doctor's wife. The critical fact, however, was that after his arraignment and his request for a lawyer, but before a lawyer appeared, the defendant was taken without the lawyer to the hospital where the very badly injured spouse identified him, and the identification was allowed in evidence at trial. And this Friendly held, although with a marked lack of enthusiasm, violated the defendant's right to counsel as he construed the Supreme Court precedents. Now, given a warehouse of other evidence against the defendant, it was quite likely that on retrial in state court, which is what the panel had ordered, the defendant would again be convicted. But the defendant had now announced that he was proposing to raise at the new trial an insanity defense, which he had not tendered at the original trial. In a closing footnote, Friendly simply posed the question, which he left the lawyers and the state court to explore at their leisure at the retrial, whether under New York law he would be entitled to raise an insanity defense that he had not raised at the original trial. Now, this sense of the practical, not just the abstract doctrine, but what it was going to produce, what the consequences were going to be, infused the judge's persona. Learned hands leisurely and stimulating speculations about the concept of invention under the patent laws or the ideology of those who passed the Sherman Act have very few counterparts in Judge Friendly's decisions. Just as he had driven himself fiercely in practice, he wrote his opinions in a burst of energy. He drafted in longhand. He normally edited the drafts once with his law clerk after the cite check. As the edited draft, festooned with paper inserts clipped to the pages, passed to Friendly's secretary for retyping and circulation to the panel, the law clerk watched him sweep the briefs into his outbox and turn immediately to the next case. For most judges, the first draft of an opinion is discursive. But Friendly's power of mind produced sentences that were often dense in thought, condensed or compressed in expression, and remain so in the final decision. When a law clerk once proposed to him a fuller explanation of a pivotal ruling in an important case, Friendly replied tersely that Henry Hart will understand it. His off-cited decision in T.B. Harms versus Eliscu, which clarified dramatically the rules of federal jurisdiction in disputes about copyright ownership, was a dense discussion of precedent and variations in fact patterns, but it consumed about 7 pages in the Federal Reporter, nothing more. This concision actually lends Friendly's opinions a kind of energy and pace, even if the reader sometimes has to take longer to decipher the sentence than Friendly took to conceive and to write it down. But it didn't make his writing dull. He had this well-stocked mental library and often decked out the decisions with witticisms or scholarly asides that entertain as well as educate. Addressing a statute of limitations issue, to provide an example, Friendly observed that it might seem clear to one, quote, without the burden of legal knowledge, close quote, that the pertinent New York statute gave the plaintiff 3 years within which to sue the railroad in New York, even though New Jersey would have dismissed her action unless brought within 2. But, he continued, the issue is not that simple. And there followed this miniature one-sentence treatise. Story's famous principle that limitations are a procedural matter determined by the lex fori. C. Leroy versus Crannonshield, Massachusetts, 1820. Commentaries on the Conflict of Laws, Bigelow, 1883, evoked opposition, both from adherents of the obligatio theory, such as Mr. Justice Holmes, C. Davis v. Mills, and Professor Beale, 3 Conflict of Laws, and from its foes, C. Lorenzen, the Statute of Limitations and the Conflict of Laws. Perhaps the most difficult problem for a judge, adverted to earlier, is when a tension arises between the law as it's been laid down or as it may be reformed in the case at hand as far as possible. And on the other hand, the proper intuited outcome for the case, measured by broader criteria. The latter include, it seems to me, a sense of what the law would suggest absent the trammeling precedent or statutory provision. But it also includes conceptions of fairness, public acceptability, the socially desirable outcome, considerations of that kind. Now, of course, all of these considerations may justify the judge in reshaping the existing doctrine, but you can have stubborn statutory language or a binding precedent that forecloses that kind of a change. And the resulting conflict, which is really a conflict between the is and the ought, creates for a gifted judge an opportunity to reconcile the law with justice, or in a more prosaic phrase, a fair and reasonable practical result. Friendly had this gift. A lovely instance is a Friendly opinion reviewing an order of the now defunct Interstate Commerce Commission. The respondent company, the company charged by the commission with violating the statute, performed a matchmaking function between people who wanted their cars relocated to another city but did not care to drive them, and students or others who were willing to drive the cars and looking for free transportation and would take the car and deliver it to the owner who traveled by rail or by air. At this time, the ICC had the power under the statute to restrict the number of interstate motor carriers by granting or withholding a certificate or permit to perform such carriage. And the ICC said that this requirement of a permit applied to this company, which it said was effectively engaged in carrying automobiles from one place to another. It held the company was operating illegally, and a district judge had then set aside the ICC order, and the case went to a panel presided over by Judge Friendly. His decision perfectly accommodated the command of the law with a desirable result. He agreed, as the district judge had found, that the company was not, in fact, transporting cars. The people who drove them were not its employees. Nevertheless, he explained that the statute, by its terms, defined common carrier as one that, quote, holds itself out to the public, to the general public, to engage in such carriage. That was the statutory definition. And the company's holding out in its advertising blurred or ignored the fact that transporters were independent of the company. And so it effectively did hold itself out as a transporter of cars, and it competed with other companies who were carriers that carried cars and had permits. So Friendly ruled that a certificate was required. But of course, the requirement that that entry into the motor carrier business be governed by some agency and denied on economic grounds, as opposed to requiring safety specifications, never made any sense at all. It was abolished, the power to do so was abolished even before the ICC itself. And the respondent company was obviously performing a useful function with none of the usual trammelings of common carriage, and it was just the kind of innovation that the ICC, now decrepit, tended to suppress. In fact, not long after, the ICC fought a losing battle against the use by railroads of supersized hopper cars, because although they saved shippers money, they competed with trucks. One could imagine what they were going to do on remand to this interloper. But Friendly anticipated the outcome. Toward the end of the decision, he observed that the company's useful service was not barred because it was free to seek a certificate from the ICC. And then, in a footnote that is as perfect in its own way as the little reflection in the mirror in Van Eyck's portrait of the National Gallery, the wedding portrait, added a footnote, and one can picture the somewhat sour smile with which this was written. We are unable to share the company's fears that an application for a certificate is sure to be denied, presumably on the ground that its prior unlawful operations show the company not to be fit. The Commission has not regarded such prior illegal operations as a bar if these were conducted in the not unreasonable belief as to their legality, a test rather clearly satisfied when they have passed muster in the reasoned view of a district judge. Part of this ability to make the law and the outcome mesh had to do with Friendly's immersion in his own work, in the record, in the briefs, but also in the drafting of the opinion. It is in the course of this kind of immersion that the thoughts occur to you, as they will not occur as often to an unseasoned law clerk, that this is the way to handle the problem. But of course, circuit judges today handle 300 or 400 merits cases a year. They write published opinions on the order of 30 to 50, and superintend many more. And it's not practical for most of them to do what Judge Friendly did. One doesn't have to be romantic about the earlier era. Many of the opinions, although they reached sensible results in the common law genius, were pretty awful. But a complicated case is like a jigsaw puzzle with multiple solutions, often as to reasoning and sometimes as to result, none of them being inevitable. And the court can notice issues not raised, it can forgive waivers, it can remand for more development or explanation, it can decide half-raised issues or defer them. The effect is a sort of great mesh. You almost have to visualize the railroad tracks snaking out of a big terminal, crisscrossing, moving in different directions. And the judge is constantly faced with choices about which fork to take and judging what will occur further down the line if this fork or that fork is taken. And the judges tend to do it better than the law clerks. Now, the fact that he wrote with wit and scholarship and a personal style, which law clerk written opinions can't really replicate, were part of what gave his opinions carrying force. But the truth is that the ultimate power in them lies in their willingness to grapple with whatever the real underlying issue is. Most judges tend to get results right out of instinct. But they often pass over the central problem at the heart of the case. The opinion may, for example, state the law and facts, but fail to explain why the facts led to the choice of this principle of law rather than a competing one. Friendly, by contrast, is always illuminating his subject as if by a great searchlight. His archived materials are filled with notes from other judges saying, I disagreed at first, but your opinion has persuaded me. But whether persuaded or not, you were always educated. Now, some may think that all this is only to be expected from an appellate judge, even if Friendly did it better than most. On the contrary, other judges, including very fine ones, have done the job quite differently. Brandeis was essentially an impassioned advocate on the bench. Black was this odd mixture of populism and, in his own mind anyways, literal construction. Wisdom and Tuttle, who were heroic figures, but were as much a part of the struggle for civil rights as they were above it. And in time, one comes to see that there are many models in being a judge, and in a collegial bench, probably the diversity is a benefit, and perhaps different times call for different kinds of judges. Still, reading a term's worth of Henry Friendly opinions, one may come to believe that Friendly's way of judging has a timeless attraction. The predicate mastery of precedent and the record, the care alike for doctrine, for equity, for reasonable outcomes, for social need, the candid expression of the result, an awareness always of the limits and of competence of judges. Llewellyn dedicated his book to judges, which we began, to those he called a part of the great grand tradition of the common law, mentioning Mansfield and Hand, among others. And this was the tradition that Friendly made his own and enlarged. By a curious chance, Friendly's only long meditation on the craft of judging came early in his judicial career in the Storrs lectures at Yale. Following tributes to the past giants, Friendly offered a closing lament that after Hand, neither the judges nor the work available to them is what it once was. Construing the Fair Labor Standards Act, Friendly said, is not the same order of intellectual achievement as solving the problem of proximate cause in Paul's graph. Consolation, he concluded, is to be sought in the worthy task of tidying up the law and repairing small chinks and leaks in the cabin of doctrine. Now, his concern that the role of judges was narrowing made him a poor prophet. The Warren Court's rapid expansion of constitutional law's domain and the successor justices have scarcely been more timid, even if their substantive views are different, have led to remarkable expansions of the authority of judges. To make a law that Congress cannot change in a constitutional realm is not a minor office. And the number of subjects that are now constitutionalized is phenomenal. Family law, evidence, civil service protections. This would have stunned a 19th century lawyer. And it's not small beer to have the nearly final word on federal statutes, since they're rarely amended in an era when federal statutes regulate everything. As to the caliber of judges, Judge Friendly shows that greatness did not end with hand. His opinions embody and reflect the experience of a lifetime of extremely hard work. Hard work in class, in a law office, in the company, and in court. And so they are in some measure an autobiography of Judge Friendly. But Friendly's opinions fit another genre as well. The issues he's decided have been or will be overtaken by events. But the way he went about deciding them remains to instruct. Nathaniel Bowditch's 1802 manual on navigation taught generations of mariners how to navigate. Gray's Anatomy, which was first published in 1858, is now in its 40th British edition and still educating young doctors. Judge Friendly's legacy of the incomparably fine opinions can do as much for judges. Thank you.